Welcome to today's LawWorks Legal Primer series webinar on understanding employee rights in organizational restructuring and closing. Now, this LawWorks webinar is organized by Pro Bono SG and in collaboration with NTUC. My name is Regana and I'm your moderator for today's webinar. It's my pleasure to welcome our amazing panelists for today's webinar, Mr. Chong Yee Leong and familiar face Patrick Tay. Now, Yee Leong is the co-head of Allen and Gledhill's International Arbitration Practice and the head of Restructuring and Insolvency Practice. A senior accredited specialist in building and construction law, Singapore Academy of Law 2018. He brings over 34 years of experience in cross-border disputes and major restructuring. His arbitration work covers complex construction, energy, oil and gas, and infrastructure disputes across Asia and Africa. He is consistently recognized as a leading dispute resolution practitioner in the Asia-Pacific region. Yee Leong has also acted in some of Singapore's most high-profile restructuring matters, including high-flux restructuring, the turnaround of Pacific International Lines, and the judicial management and liquidation of the Hing Leong Group. His work often involves navigating legal, regulatory, and technical challenges in high-stake commercial contexts. Next, of course, a familiar face on this panel, we have Patrick Tay. Patrick is the Assistant Secretary General of NTUC and the Director of NTUC's Legal Services and Strategy Division. He is also a Member of Parliament, representing Pioneer SMC since 2020. Thank you both for joining us today. So let me start. When a company starts to wobble, then rumors of restructuring, delayed payments, sudden cost cuts, uncertainty really spreads fast across employees. And when the company closes down, some workers are left in the lurch, right? Unpaid salaries, unanswered questions about CPF contributions, and there's a lot of anxieties in those private group chats amongst colleagues. So today is about replacing assumptions with facts in clear, practical terms. Together with our panelists, we're going to unpack terms like restructuring, retrenchment, redundancy, insolvency, and liquidation, and what it really means. What happens to your employment contract? What protections exist for wages and CPF contributions? Where the real risk lies, and what recourse and support is out there for you. So as we go along, please send your questions through Pigeonhole. I will do my best to bring them all to our panelists here at the right moments. So I'm going to start with Patrick first. Now, Patrick, we are operating in a climate of really global uncertainty, and workers in Singapore is not immune to this. From where you sit, where are you seeing on the grounds in terms of restructuring, retrenchment, business closures, and how is it affecting our workers?
Thanks, Regana, and thanks everyone for joining today's session with a particular focus on restructuring, reorganizing, including business closures, something quite close to many of our hearts. Why do I say that? Because even in good times, companies do face challenges, a variety of challenges, and sometimes businesses have their own ups and downs. And as you can see, even like last year, where we had quite a sterling year, a good economic growth, 4.8%, but there are still quite a number of layoffs. In fact, round about, it varies. In the last 10 years, if you look at the number of layoffs, minus those more painful years like global financial crisis, SARS, even COVID, you get about 10 to 15,000 people being laid off via retrenchments annually. Including last year. Last year, I think the full year's figures are not completely out, but round about that number. But I thought before we go into that, you have to recognize the fact that retrenchments or reorganizing and restructuring happens. It happens all the time, but it doesn't mean that the company will close eventually. Later, we'll talk more about whether any hints of financial losses or challenges, or even now with generative AI and its impact and its disruption, does it mean that the company will eventually always end up closing shop? Not necessarily. So that's why we have the series of measures, that's why we have a series of laws, that's why we have a series of arrangements, including tripartite advisories and guidelines, etc., to help companies navigate. And of course, workers, more importantly. So I think this evening session, just to bring everyone up to speed, you've read the news, many news, even well-known names like 12 Cupcakes and name it, but and the variety of companies that we have seen and heard on social media and in the mainstream media about closures, sudden closures, non-notification of affected workers, etc. So I think tonight we'll try to unpack some of these and give you some practical handles. Both Eden and myself will try to answer some questions later on also, but I think more importantly is to help you navigate this very complex area, because not like I mentioned earlier, not every company goes into liquidation and closes shop all the time. For want of a better word, closes shop. Well, reorganizing and restructuring happens quite regularly for companies, whether big, small, or even medium size. And therefore, we will go into that in more details.
Thank you, Patrick. And you are right. There's a lot of things happening and changing. So before we actually deep dive into the rights and protections, it's important that we get the language right, because there's a lot of anxiety when big legal terms are thrown around, and even I sometimes get really confused, and it's scary. So before we start, Patrick, could you help me clarify the difference between redundancy and retrenchment? And could you explain why workers should understand these terms?
Yeah, these two terms are important. Why? Because it boils down to something called the retrenchment payout or the retrenchment package. Well, that's why the word redundancy and retrenchments are both important words. Well, a company can terminate a worker, but however, in cases where, well, because of restructuring, reorganizing, or maybe wanting to do some cost-cutting measures, they actually retrench people, then that's where sometimes, because of the employment contract, by operation of a collective agreement, if it's a unionized company, or by operation of the practice of the company, they may give out a retrenchment package or payout. Some call it severance package. Well, some call it golden handshake. Well, a variety of terms and nomenclature. But more importantly, the key thing is this retrenchment package and this so-called compensation to help you, tide through the period where you're out of job. But why then the word redundancy? Because if you look at retrenchment, it's quite a big word, because when you go into a dispute, especially when there's a claimant or one of our union members who are affected by retrenchment, then we'll ask and we'll have to look at the whole exercise of termination and laying off, because there are situations where there's a disguised retrenchment, meaning that they call it retrenchment, but they don't use the word retrenchment. They just say, "Oh, you're terminated. Your services are not needed." But actually, the main intent was to retrench you, because they don't need workers, or they have closed a product line, or they have closed a particular department, or they decide to reshore, offshore. So that's why the word redundancy is important, because to tantamount or to amount to a retrenchment, there should be some form of redundancy. Yeah, not because it's a poor performer or don't meet the mark or KPIs, but more importantly, the keyword is redundancy. So when there's redundancy, that's the key thing that we are looking for, where because of, as I mentioned earlier, product closures or even reshoring, offshoring, or maybe outsourcing of certain services, and there's redundancy of that role or position, then the word retrenchment comes in, and possibly a retrenchment package, depending on whether there's a provided in the employment contract or, I said, by operational law through a collective agreement, etc.
Thank you very much, Patrick. That's quite clear. So, Yee Leong, when I come with those big legal terms now, when employees hear the word restructuring or business reorganization, what does it usually mean? Does it automatically mean everyone's losing their jobs?
Far from it. When you talk about restructuring or reorganization, it can be in a various different kind of circumstances. I suppose the most benign type will be when a company is looking at the products and they're saying that, okay, my product is going to go obsolete and I will need a new product, and then they have a new product line. okay, or they have a new area of business they want to get into. So the existing organization is no longer suitable as organized for the new product line or for the new area that they're getting into. That's why they're going to reorganizing and they are going into restructuring the operations. That, I suppose, will what be called a very benign, or well, less disruptive kind of reorganization, because the company is not in trouble. The company is still a good going concern, but they are just looking at how to restructure the business or the operation to suit the new area that they're getting into. So in fact, I was saying that jobs shouldn't be at a risk unless, of course, the workers who are in the line that are shutting down cannot be retrained or reskilled into the new area. So that's the one area that you may want to look at if the company that's going to that kind of restructuring. But a lot of times too, you can have restructuring when the company is getting into financial distress. Now, for even financial distress, there are different level of financial distress that you can talk about, right? Let's start off with the most severe kind of financial distress, insolvency. What does insolvency means in the legal term? Insolvency in legal terms means that the company is unable to meet all its debts as and when they fall due within 12 months time frame. That means that if as and when the debt fall due, they cannot pay out within 12 months time frame. And that is insolvency. Okay, and when you have insolvency, you immediately face a few problems. One is that the directors may be at risk if they continue to trade if the company is insolvent, because it is against the law for them to do that. And the other thing is that if they don't do anything about it, it looks like the company may be going down the hill, and at the end of the day may end up in liquidation. Another term that we will explain later. So a lot of companies then do what they call reorganization, restructuring, in terms of trying to maybe get the creditors together to take a haircut, to help the company to tie over the difficult period. And also, I think during such time, usually companies will face a lot of lawsuits. So you go to court and try to get a moratorium to prevent company from a lawsuit from being initiated against the company. And those kind of restructuring, of course, is going to be more disruptive for the workers. But even then, we will have to look at the kind of legal structure that they're going to. One very common legal structure is what we call judicial management. Judicial management usually is when you go to court and you apply to court, either our creditors will apply to court or the company itself can apply to court to appoint a judicial managers. And the judicial managers can come in to do one of three things. One is to help the company rehabilitate their financial situation. Two is to go into a scheme of arrangement. The scheme of arrangement essentially is an arrangement endorsed by the court where the company creditors usually take a haircut or convert some of their debt into equity, or some other ways to help the company reduce the debt that they have, or three, to achieve a more advantageous realization of the assets than in a liquidation. In that case, the judicial managers, once they are appointed, they will come in. It doesn't mean that the employment contract is terminated. The employment contract continues because the company continues. But judicial managers, as you all know, will have to deal with the workers. One of the first thing a judicial manager do when there's judicial management is to review all the employment contract and make sure that there is enough money to pay the workers as they continue working, because they do not want to lead the workers down the garden path and then not pay them at the end of the day. That's one important thing. And the other thing also they usually will try to do is to try to maintain the operations as much as possible, because without operations, really, there's nothing to save, right? So that's judicial management. Another kind of restructuring is not judicial management, but what we call a moratorium scheme of arrangement. That means they go to court and get a moratorium. And a moratorium simply means that they will try to get protection from the court to prevent companies from launching suit against them, to give them a breathing period. But the management remain in control, as opposed to judicial management, where the judicial managers come and take over the company. in a moratorium scheme, the management continue to be in place, and then the company, usually with help of insolvency practitioner and restructuring experts, restructure the whole organization. Okay, and in that case, also the employment contract continues, but obviously, they will have to see whether if there's efficiency to be achieved by restructuring the employment, restructuring the departments and things like that. In fact, one of the most successful moratorium scheme that I've done is the Pacific International Line restructuring. It is one of our largest shipping line, and is well known throughout the whole region, right? And it went through a difficult period because shipping was going through a tough time, and they went into restructuring. The company actually saw that they went into restructuring, went through a scheme to get the banks to take a haircut, and came out of it very healthy. In fact, came out of it with even stronger operations. And the wonderful thing about that story is that subsequently the shipping line market went back up, and they made a lot of money in the restructured form. So what they did was they actually told the banks who took haircut, they say, it is not fair for you to take the haircut. Now that I have recovered, I will pay you back all the haircut that you have taken, although legally they were not obliged to. Okay, so that is a very, very successful story of restructuring. And in that case, as far as I understand it, none of the workers were affected by the restructuring. So those are the kind of insolvency restructuring that you can look at. But if you move a little bit more, sorry to be taking so much time on this, right?
It's very good.
Is that the company may not technically be insolvent yet, right? The company is still able to pay the debt, but they look down the horizon, they say, oh my God, there's dark clouds in the horizon. They are seeing trouble ahead, and they will need to do something quick. If they don't, then they will end up in the insolvent situation. And those will be the in between the two types of insolvency, the two types of restructuring that I'm talking about, where the company takes proactive measures to restructure, to maybe make life in the sense more efficient, and then they may then look at the workers to ask workers to help them take a little bit of pain to help them through the difficult times. Like, for example, they may ask the workers to say, okay, during this difficult period, can you help out with maybe take 3/4 pay, with maybe a 4-day work week, and we will try to go through this period together. Now, having said that, it has to be clear, the workers are not obliged to help out, because under the employment contract remain in place, and the rights are still in there. But it is, I suppose, effort by everybody, by the company, by the workers, everybody, to try to go through this. And if all the workers agree, you can do a sort of like a restructuring in that sense, and hope that the company can go through this difficult period and recover. And sometimes when the company recover, then you can go back to life as per normal, and maybe even some kind of a repayment of the sacrifice that the worker have taken. So those are the different kind of restructuring that we're talking about.
Just to add to what Lee Leong mentioned earlier, I think important for all of you who are tuning to be aware that in Singapore, we kind of do things a bit of like a tripartite way.
Yeah, correct.
Yeah, government, in this case, Ministry of Manpower, the union or the workers, in this case, NTUC, as well as our Singapore National Employers Federation representing the companies and businesses. I think very, very important to take cognizance of the fact in Singapore, we have this document called the Tripartite Advisory on Managing Excess Manpower. We added 3 other words behind, and responsible retrenchment. So actually, this I mean, being in NTUC for slightly more than 2 decades, I remember the genesis of this. This started because this set of guidelines started during the global financial crisis, 08-09, I remember. And then we came out with these guidelines because I think the key mantra is we want companies in Singapore to cut costs to save jobs, not cut jobs to save costs. I think that was the mantra. And therefore, we want to help companies to tide through the difficult period. That's why Elon alluded to earlier about how workers can work closely with management to find ways to manage excess manpower, because maybe it's a time of restructuring, reorganizing, or maybe business is a bit down, a bit cyclical, downward cycle, and therefore measures to reduce costs. Well, various measures they are in place. If you look at the tripartite advisory, we have shorter work weeks, we have sometimes compulsory shutdowns, compulsory consumption of leave, and this is usually in a unionized environment, something negotiated or discussed with the union and the workers, and therefore, right, spot on what Leong mentioned. They are not forced by law, but I think everyone wants things to work out for the better. They want the companies to come out hopefully unscathed and as a going concern. So therefore, there's this set of tripartite advisory, and that's our rules of engagement in the labor movement as well. To help companies to stay alive and stay afloat. But more importantly, also in that same advisory, there's also alluded something new called responsible retrenchment. Because anybody can carry out retrenchments. In Singapore, retrenchments are not prevented or not stopped by operation of law. However, there's room for negotiation of retrenchment packages, usually in the unionized environment. There's a provision for retrenchment in the Employment Act, although it's a phrase in a way sort of like a negative eligibility clause, but otherwise there is a provision, and there are sort of like benchmarks and proxies on payment of retrenchment benefits in the set of tripartite advisory. So I do urge employers and sometimes HR or even employment lawyers who are in this in this area of law to scrutinize the advisory front to back, because it serves and augur well to be familiar with that, because if a dispute eventually goes to example TADM, Tripartite Alliance for Disputes Management, or even to Ministry of Manpower, or even worst case escalated to the Industrial Arbitration Court, there's a lot of reference to this advisory and the respective guidelines, including sometimes guidelines relating to this. And finally, I what Leong raised earlier about everybody chipping in to minimize costs through, for example, taking a small pay cut. Actually, this is not new. Singapore implemented the flexible wage system a couple of decades ago. I think through time we kind of like forgot about it, but actually there's something called your fixed component of wages, your basic wage, your annual variable component, and the monthly variable component. This is still a very active thing in many of our companies and even the public sector. So I recall quite vividly during the global financial crisis, including during the SARS outbreak, where there was a sudden downturn. I think a lot of companies were trying to stay afloat as a going concern, and therefore had a lot of discussions, negotiations with the unions, and to how to see the best way out, short of laying off people, which is the final option and the thing of last resort. We try to see how to help companies to manage the costs. All of us know very, very fresh memories during the COVID-19 pandemic during 2020, 2021. Many companies and businesses had shutdowns, were going through a difficult period. But thankfully, I think my personal experience in those 2-3 years was that there's a lot of government support in terms of jobs credit and job support, and therefore helped quite a bit to alleviate some of the cost concerns of some of the companies. But of course, there are those that had no choice to shut down, sometimes because of global HQ decision, because we have a lot of multinationals and global companies right here in Singapore. And therefore, sometimes it may be because of a global or headquarters decision. But otherwise, I think they know in here we have the respective advisories, guidelines to navigate and to help companies to do well, and for workers to be fairly treated and paid.
Thank you both. Yee Leong, you've answered all my questions, so I'm going to go to the audience. A question for you. What does it mean if the company is gazetted to be struck off? Does it mean that the company is going into liquidation?
Well, okay. Then let me explain the process of liquidation and striking off first, right? Now, when a company goes into liquidation, that means that the company is going to be, the operations are going to stop. The company will stop carrying on business and will stop all its operations. There are two types of liquidation. One is a solvent liquidation, Another is the insolvent liquidation. Now, the word solvent and insolvent, I think I have explained the difference just earlier on.
Yes.
So when you have a solvent liquidation, essentially it is a company that has actually have enough cash to carry on, but for various reasons they want to close down its business. It could be because there's no successor to take over the operations. It could be because the business owner felt that he wants to do something else and do not want to carry on with the company anymore. But the company has money, and therefore they go into a liquidation, what is called a members voluntary winding up. That means the directors will vote and the shareholders will vote to put the company into liquidation. And they have to give a certificate of solvency. That means that they have to certify that they have enough money to pay off all the creditors of the company. So what happened is that then a liquidator will be appointed, and the liquidator's job really is to wind down everything, collect all the money, and pay everybody off. Okay, and of course for the workers, you can imagine the employment contract will probably be the employment contract will be terminated because there's nothing else to do in terms of the company's operation, right? But you'll be paid your wages, and you'll be paid if there's any damages that comes from the termination, or if they terminate you based on your notices, 3 months notices, all those have to be paid in full. So the workers will not be prejudiced or compromised as far as that is concerned. And once that whole process is finished and the liquidators have done their job, then the excess money that is left will be paid off to the shareholders. And once that is done, then the liquidators will apply to the company's to ACRA to strike off the name of the company. That means once the name of the company is struck off, that's the end. No more, that company does not exist anymore. That is a solvent liquidation. Now, in solvent liquidation, the process is similar, except that the company is really insolvent. That means that the company does not have enough money to pay its creditors. So once the liquidators is appointed, then the liquidators, the first thing they will do, all my liquidators friends tell me, the first thing they will do is that they will also quickly look at the employment contract because it's very important. It affects people's life, right? So that's the first thing they will do, because liquidation does not necessarily terminate the employment contract. Now, there are two views to it in the law, and it's not clear which one prevails. One says that once the company goes to liquidation, the employment contract is repudiated and that's the end. Another view say that no, the employment contract continue, but doesn't matter whichever view prevails. The liquidators will decide once they go in, okay, which of them they need to terminate immediately, okay, because the operations cannot carry on. But they may want to retain some employees because, for example, accounts will need to be finalized. There may be other things that they need workers to help them to close down operations. So the liquidators will come in, and most important, if you are a worker in a company, touch wood, in a company that's being liquidated, most important thing is to get clarity from the liquidators as to your status, as to what is going to happen. And then the same event happened, and the liquidators will then start selling off all the assets, try to recover as much money as possible. And under the Act, then the liquidators will distribute the money that they've collected. There is a priority ranking. The top is, of course, the official receiver. If the official receiver is involved, the official receiver get paid off first. Then the liquidators' fees get paid off. Then after that, there will be the worker's salary that goes in. The worker's salary followed by any retrenchment benefit, if there is already retrenchment benefit. Then any workers' injuries compensation. Then I believe there is also, if I'm not wrong, just hang on. There is also the CPF that we talk about, right? And then taxes, right? Those are the priority lists. These are what we call preferential debts. After the preferential debts have been paid in full, if there's still money left, then the money will go into to pay the unsecured creditors. So that's the ranking in terms of the priority of that.
Sorry to interject, but this I've been handling in the past years quite a number of these situations. Companies winding up, liquidation, going to judicial management.
Yep.
few questions came to my mind. Okay, but the very first one, a couple of questions, but the first one came is based on because you're insolvency practitioners, you've seen many of these arrangements.
Yep.
So how often, because you have the priority of debts,
Yeah.
but because you always pay the secured creditors first.
Yes.
But by the time they pay the secured creditors and the receiver or judicial manager or the liquidator, I'm just concerned because even though workers' wages are almost the top, short of the liquidator, but how often, based on your experience, you've seen that the workers actually do get paid?
To be fair, to be frank, I think it's not often that there's enough money to
That's
flow down
important,
to the preferential creditors, right? Although the preferential creditors actually have preference, it's not common, especially when you are liquidating a smaller company where the assets is not a lot, right? Of course, if you liquidate one of those massive companies that we talk about, then there's enough. No, I wouldn't say plenty, but there's enough, to take care of the preferential creditors. And in fact, sometimes even the unsecured creditors get 10 cents to the dollar for the debt that they have. For example, I think in Hin Leong, the recent liquidation in Hin Leong, there was enough to pay the preferential creditors. And I think that even the unsecured creditors are getting some payout as well.
Yeah.
But it's not common in my experience, for that.
But that's good practical advice because for what Leong mentioned, that the fact that it's not common. So all of you, it's good to, as a practical advice, watch out for red flags.
Yeah.
And manage expectations also.
Because sometimes you know the company, get a hunch, sometimes let's for example, you look after the store and then the order books are empty, and then traditionally, when the company is doing well, you get full stock in your warehouse and it's getting empty and seems things are getting a bit quiet. I think these are red flags to tell you that, it's good to, well, in a unionized environment, we actually go very fast in to the company to check in with the HR and the management. But I thought as a good sound advice. Yes, if we really get into the edge, like what Leong mentioned,
too late. It's a bit too late.
That's the challenge.
The red flags actually, I would say, is if debt collectors keep turning up at the door, right? If the company gets sued, and those are really red flags. And I think if you see that, then of course you got to start preparing yourself. And maybe start looking for a new job, and
That's right.
looking for alternatives. Those are the things that you need to do. But back to the storytelling again, sorry. So once the liquidators finish that process, and then they will again apply to ACRA for the company to be struck off. And again, once the company is struck off, that is the end. No, the company doesn't exist and it is called dissolve, right? So that's the difference between liquidation and striking off. So the liquidation is the process in which you clean up the company and try to get as much payment out to the creditors and the preferential creditors as possible. And then once you have done that, if there's nothing left to be done, then the company gets struck off.
So if the company is on its way towards liquidation, can the company impose pay cuts, unpaid leave, shorter work weeks? And does that take over the original contract? I think I was asking you before. Do they need a new kind of contract when it comes to new structures to that?
I think if you're talking about the pay cut, the shorter work week and things like that, that will be before liquidation. Because once liquidation starts, then you can't do that anymore. That will be the end of the process.
So there'll be negotiation.
But before that point, before you reach that point, if the company is trying to restructure itself, trying to get back on its feet, then of course the contract is written in the employment contract, set out clearly all the rights. But of course, parties are at liberty to vary the contract
and negotiate.
Yeah, and negotiate and try to help out in terms of, trying to help the company to weather the difficult time, and hopefully like PIL, go through a restructuring and come out stronger. So in that kind of a situation, employees and employer can come to an arrangement where they can vary their rights under the contract. And if the employee agree, like I say, it is not imposed by law, it's not imposed by anyone. The company cannot just overnight say, hey, tomorrow you're going to work shorter week and I'm going to pay you less. They can't do that. They need to seek consent of the workers. But if the workers all agree that, this is the right way to do it, they can vary the employment contract and say we will have this reduce work week and reduce pay for a certain period until, let's say, 3 months. We will review the situation. Let's look at see whether 3 months down the road things get better, and if it doesn't get better, what are we going to do about it?
That's why we try annually through our National Wages Council guidelines and including the flexible wage system to build this already during peacetime when things are good, and you can actually sit down, negotiate, discuss, so that come crunch time, you don't have to worry about recalling everything. You can it's easier when you have already agreed on some of the formula to the flexible wage system, to how to activate and when's the trigger point, what are the triggers, when do we restore. I think these are things that we have done in the past couple of downturns, and it has worked very well, so that you don't go into a very, very, very when I say a contentious situation. It's a very, very collaborative, trying to help the company to revive, not having to push it off the cliff.
Well, thank you for sending your questions. We have a couple of questions, Yee Leong.
Yeah.
For S18A transfer, the same employment terms must be offered. Someone's asking. For the basic salary, this is straightforward. What about incentive schemes? What happens if the new employer doesn't have this?
Well, okay. Let me try and understand this question. What is a S18A transfer?
I am also trying to figure this out. Maybe I could get some.
Yeah, maybe I chip in.
Yeah.
Okay,
on this.
help us.
Yeah, 18A is a provision in the Employment Act to allow. Actually, the genesis of 18A is because when there's a sale undertaking by a company to another company, for example, sourcing a specific function.
Right.
Yeah. That's where we start looking at the entire transaction, whether it's a complete sale and transfer, and therefore whether it attracts retrenchment benefit. Because if 18A operates, then there will not be sort of payment of retrenchment benefits.
Because it's life for life.
Yeah. So like you still continue this. It's just because of that, the arrangement. It's not a redundancy situation. It's just for one of better mergers and acquisitions, it happens a lot where 18A is involved.
Right.
But when the situation don't fall within 18A, then you have to pay your because it's really redundancy. So 18A was the genesis of it was to allow companies to be a bit more flexible, to provide, particularly when sale and purchase of companies, acquisition, mergers. So that's 18A for you. But I think the question alludes to the fact that 18A actually does some protections. That once you operate 18A, you don't get a retrenchment payout. But however, your terms and conditions should remain. So in a unionized environment, we will have to negotiate with the new employer, because company A may have, because 18A, the workers lock, stock and barrel transfer to company B, and therefore they will have to honor some of the terms. So what we call the no worse off principle. Yeah. So most of the terms should continue, including the years of service. That's what we try to negotiate in a situation where we activate 18A. However, there's a period of time as prescribed by 18A, and therefore it will not be forever the same terms. There may become a point of time, particularly, for example, you from a unionized company to a non-unionized company, for example, then we have to go through the whole recognition process again. Although the new company, in most cases, recognize the union, but when it becomes a minority, then you have to still go through the rigmarole of getting recognition, etc. Because now you're part of a larger outfit or organization. So just to watch that. So if ever any of you gets involved in 18A, first see whether it's really 18A or not. I wouldn't let the cat out of the bag, but I'm part of the tripartite work group reviewing the Employment Act, and I hope, and I've been lobbying in the past couple of years to provide a bit more clarity. But even today, employment lawyers also, scratch their heads. Is this an 18A or is this not 18A? Because it's slightly ambiguous. So hopefully, with the upcoming Employment Act amendments, we will provide more clarity to everyone, to either through an exclusionary approach or inclusionary approach to say this is or this is not 18A. And therefore less dispute over whether I pay retrenchment benefit, whether my terms continue, and what happens next. So I think we're doing that to provide more clarity. But in the meantime, watch whether it's 18A, and hopefully you're in a nice environment where we can advise you. But if you're not, then Take note that there are some provisions. All else fails, go to the MOM website, mom.gov.sg. They do give you some FAQs on navigating 18A and what 18A involves.
Okay. I'm gonna ask you another question to both of you, maybe just to help this participant. The department was closed down and the employment contract was terminated. Reason giving restructuring of the business. The person's contract does not state retrenchment benefits, but is stated in the company's handbook. Is this person entitled to retrenchment benefits?
I would say if it is in the company's handbook, okay, and presumably all employees are supposed to comply with the company's handbook, then it is a term of the contract. And if it is a term of the contract, then obviously if it fits the definition of retrenchment in the handbook, then that person should be entitled to retrenchment benefit. That would be my reading of it.
Yeah. So no, totally in agreement. Frankly, employment contracts vary. Yeah. Now you have to write it out and be 1 page or some even 20, 30 pages.
Yeah.
So it all depends. I see some practices are such that, there'll be a main employment contract for each individual or each individual employee. However, oftentimes, through expediency and for regular updates, they do slot in some of these updates through a HR circular or memo or a handbook. Yeah. So in most cases, like what Yee Leong mentioned, it could be a cost of dealing that such handbooks are sort of terms and conditions. They are an extension of the employment contract. Some employment contracts actually make explicit mention. Any updates will be as provided in the company handbook. So I think if it's clear, that it's good. If not clear, then you need to justify that actually most of the terms and conditions are actually embedded in the company handbook and therefore should form part of the employment contract. And that's what Yee Leong mentioned. If it's provided there, good and well, because they may define situations. Because in Singapore we have many global companies, so the way they define it may be slightly different. But I said key principle of retrenchment is there must be redundancy. Yeah, redundancy. The operative word is redundancy. So if it's not redundancy but a termination, a contractual termination, then you need to scrutinize the entire termination process.
Yeah, well, the thing is that it will be difficult, I think, for the employer to say that the company's handbook is not part of the employment term because they expect all the employees to comply with it, right?
Yeah, that's right.
If they expect all the employees to comply with it, then they can't jolly well turn out and say next day that, oh, actually it's not term of the contract and I'm not bound by it. So to me, I think it will be quite difficult. But I think the issue, as Patrick mentioned, is it really a retrenchment? And that's something that you need to look at in terms of how it is defined in the contract, in the employment, in the handbook, right? And whether one fall within the definition of retrenchment as is stated in there.
Okay. So we spoke about red flags, which is very good. And the most obvious one is the along and all coming, and that is a massive red flag. But are there any other red flags that workers out there should keep an eye on? And what are reasonable measures that they should agree to keep their jobs, preferably, or any advice? Maybe you
At my end, in our unionized environment, what we do, we have regular check-ins with companies. I think nowadays companies are the most progressive ones, tend to do town halls, and they do regular comm sessions with their staff. I think which is a very, very good practice. Of course, you have the listcos or listed companies where they have to file regular updates and provide regular updates, sometimes quarterly. Some financial institutions that do it quarterly. But I thought a good practice, having learned from a unionized environment, is that I do urge employers and companies and businesses alike to be open and transparent. Because the last thing I hear is that a company is not doing well on social media, or anywhere else, or on a grapevine. So I think clear, transparent, contemporaneous communications will solve a lot of problems, including employee engagement, trust issues, and responsible progressive practice. So I think regular comms is useful. Why do I say useful? Because then it could be good news, it could be bad news, if it's good news, fair and well, everyone knows, so everyone's motivated. But it's not so good news, at least they know the company trusts and therefore it's open and transparent and want them to help the company and to tide over the difficult period. So through this many years of the labor movement, I've seen companies who tend to be very transparent, very open, and very contemporaneous in the comms tend to have a lot of trust between employer and employee. At the same time, also they tide through difficult periods better. That's my advice to employers, particularly. You don't need to be a big multinational or Lisco because of regulatory requirement. You need to divulge some of these figures, but even SMEs and large local enterprises, I think it will be a good practice to have regular comms with workers. Of course, in a unionized environment, the union actually meets up with the employers quite regularly. If it's not unionized environment, town halls and regular check-ins are great platforms to build that employee motivation, trust, and productivity.
Thanks, Patrick. You know,
I think the trust point is actually very important. Particularly if you talk about SME, where it's not really a particularly large organization, and is when you treat people like family, right? And you go through a difficult period, usually workers then are more willing to hunker down and help the company to ride through the difficult period. So that is actually very important, and to engender that trust and that loyalty in the company. I think the company has to be seen to be treating everyone fairly, to be open about it. And if you got trouble and you are open about it, I think people are then workers will be more willing to do that shorter work week or to do that reduced pay, as opposed to if no news is coming down and then suddenly you just drop the the ball and then tell them, sorry, we are in a very difficult situation, we need some help. People will start thinking, is it true that you really need help, or are you just trying to take advantage of the situation? Right? So that is actually very important. And frankly, if you talk about red flag, I think it's good that if you are workers, you are aware and you have that constant daily communication with the management. And if the management is open about it, I think you would know if there are problems.
That's right. And that's my take too. I think the communication part is key, particularly in now a very volatile, a very VUCA world. Whether it's the company being disrupted for a variety of reasons, it could be cyclical challenges or it could be whatever uncertainties. I think with close and transparent communication, nothing beats it. I've seen many companies who are able to maintain their good communications, having very, very strong labor management relationships.
yeah, thank you. And I hope there are employers out there listening in. The last thing you need is your employee learning about your company closure on LinkedIn or Instagram.
Yeah.
And that will really blow up. So next we're going to talk about CPF.
Okay.
Very, very important and also a very big concern for Singaporeans, right? And so let's deal with this, Leong. If a company is struggling or heading towards closure and somehow CPF contributions they're not paid or they're delayed, what should workers understand from a compliance perspective? Because I know there were tiers of who gets paid and so if you could just shed a little bit more light on that.
I think CPF, you look at it, is of course it's a statutory duty, right? So under the CPF Act, the employer has to pay the CPF by the end of the month. Okay, if they don't, there will be breach of the duty. And if you are not getting your CPF, I think that's the first thing you should go to your employer and say, what's happening? Why am I not being paid? And if another 14 days, meaning by 14th of the next month is still not paid, then I think you can make a complaint to CPF board.
That's right.
To compel the employers to pay up their CPF. Now, but if it comes to a stage where the employer is really cannot make payment of CPF, then I think it's pretty severe already, and you are generally looking at a severe insolvent situation. Most of the time, if you reach that stage, company is beyond help, if you ask me, right? And as you mentioned, and I have to also talk about earlier on, CPF is one of the preferential debt that the liquidators have to pay. I think it ranked at number 3 or number 4 on the list. If you have if you past the liquidator's expenses. The first one is the salary, then the retrenchment benefit, then there's a workman compensation, then there's CPF, right? So they rank in the list. But as Patrick again also has alluded, that depends on whether the company has money to pay. But if they are really in a dire situation where they can't even pay CPF before it goes into liquidation, then it's very unlikely that they will have money to go down that route.
So then I'm going to ask you this question. What can the employee do? Can they go to claims court? Can they write to TADM?
Yeah, they can. I suppose if it gets to that and the employer doesn't pay anymore, then of course they can make use of TADM to make the claim, right?
Maybe just to add on what you mentioned, I mean, prior to it going insolvent, you can still a lot of intervention measures. I mean, if it's unionized company through us, and TADM is one channel because it involves statutory claims and payouts. So that's one avenue to go to. Payment services, non-payment of CPF, a report to CPF board. There's an enforcement team in CPF board to make sure there's compliance. But actually, my main worry, having done quite a number of these cases, which maybe Yee Leong can advise or share your experiences, is and when you appoint a liquidator, judicial manager, receiver, etc., or you go through the winding up process, there's always, you might mention earlier, the key very word that I fear most, moratorium. Yeah. So whenever there's a moratorium, apparently, a lot of the actions that I used to be able to take, now, unless you leave a court, I can't take an action against the company, including non-payment for many of the things that are already there. So that's where the challenge is. So maybe Yee Leong can based on your practice, when there's a moratorium, what's the usual behavior of the liquidator, JM, or judicial manager in wanting to meet some of these obligations and even entertain some of like a call from my union sisters and brothers,
right?
Yeah, on can you share any updates and stuff like that? Well, they're always very concerned. But it's really like a black hole. They can't have access to the liquidator, they can't have access to the receiver because there's a moratorium. So any help that we can go to or any tips for us?
Yep. Okay. Let's take liquidation first, because that is more straightforward, right? Like I say, when companies go into liquidation, it's the end, right? So the liquidators will usually say that file your proof of that.
Yes.
Yeah, you file your proof of that, whatever is owed to you, whether in CPF, salary,
that's what
everything, file the proof of that. And that should be pretty straightforward and clear cut as far as that is concerned. But beyond that, I think there is really very little that you can do as a worker to try to make any further claim, because the company is in liquidation, and that you can't really start a suit. And even if you do start a suit, what money are you going to get out of this? Right?
Yeah.
So liquidation is pretty straightforward. Now, judicial management and the other one will be the moratorium scheme of arrangement. That one has a little bit more room to move, because the judicial managers, or even in a scheme, moratorium scheme where the existing management is in control, they are usually quite keen to maintain operations going on, because otherwise it's going to be difficult to rehabilitate, maybe difficult to find a white knight to be able to take over the operations, right? So in that sense, I think the worker has a little bit more leverage and bargaining position. And of course, if they completely stop payment, then you can imagine all the workers will be fleeing and going off and looking for jobs. And even if they can't get any jobs, they won't be turning up because they're not getting paid. So it's always good, again, to talk to the judicial managers and to talk to the management. And even on the unionized thing, I think it's good to engage the judicial managers. Like I say, all my judicial management friends will tell you, first thing they do when they go in is to look at the employment contract, to identify the key workers that they need to maintain operations and to keep continuity. Right, that's the first thing they need, because otherwise there's nothing to save.
Yeah.
There's nothing to rehabilitate. So it is worth your while to engage and also to find out what the intention is. If it's a judicial
that's right.
manager, what is your intention? Is your intention here really to rehabilitate? Are you going out to look for white knight? Are you looking to do a scheme of arrangement? Or are you looking for a more advantageous disposition of the assets than in the liquidation? What does a more advantageous disposition means? Usually it means that you have an ongoing business and you don't want to close it down and you want to sell it as a going concern because that will fetch more money than closing everything down, right? And to sell it as a going concern, you got to have a going concern, which means that the workers have to be there. Maybe not all the workers, but at least some key workers have to be around to keep the operations alive. So that is important to talk to the judicial managers, or if it's not judicial manager, the management, to find out what the intention is and where they are going and what are the key areas that they are looking at.
And for these schemes and judicial management, based on your past practices or cases that you handled, usually what's the time frame like? I mean, the shortest and the longest you will drag.
Oh, shortest can be as short as 3 months to 6 months. Okay, that will be the fast one that you can get going. Like nowadays, we have a new feature in the IRDA that allows us to even do pre-pack scheme arrangement. That means a pre-pack means that you don't even need to have a hearing. You just do a pre-pack, a pre-approved scheme arrangement, going there quickly, get it sorted out, and then very short time you get the scheme approved. Or there are schemes that have gone on for years, unfortunately. Yeah, there are 3 years sometimes because it is complicated. They keep trying to get extension from the court because they need to find white knight to come in and take over. So yeah, those are not the good story to tell.
In fact, those are the long ones that protracted. Delayed ones are the ones that sometimes the union may be able to step in to advise the workers there, because you can't be staying definitely
in a limbo.
Yeah, it's really a limbo, you know.
Yes.
And sometimes at half the wage, sometimes at no wage. And so we try to advise them. You know, some of them have a bit sentimental in the company.
No, they have a lot of loyalty. You know, workers who particularly has been spent maybe better part of their working life in the company.
That's right.
They felt, although not a legal obligation, but at least a moral obligation to try to help out in terms of trying to keep the thing alive. But I think beyond a certain level, the workers have to
agree,
thinking about their own future, you know, and where they're going.
Absolutely. That's why I always tell the workers. I mean, if you assess that this can be protracted, I mean, you still have mouths to feed at home. Right. You can't be indefinitely being limbo.
Yeah, correct.
So we're going to circle back to that. But before that, for Patrick, this is a question on behalf of the freelancers and independent contractors where CPF does not apply the same way, right? How should they think about this? You know, are they affected? And realistically, you know, what options do they have when their payments are delayed?
So technically for platform workers, we now have the new Platform Workers Act effective 1st Jan last year. So CPF is in play now. Of course, it's a good start. But however, if you look at freelancers in general, they are in a contract for service and not a contract of service situation. So it's basically a debt. You're owing a debt. So if you do get situations in such manner, or you're put in such a vulnerable situation, or you assess that you're not going to get paid, I think immediately the most fastest way is to go to the Small Claims Tribunal. To get, just like Employment Claims Tribunal is for employees, the Small Claims Tribunal it's been around. The claims limit has been expanded. Now, if mutually 30,000 parties is 30,000. Yeah. So actually, it's one way to get your monies owing being paid. At least you can get a judgment from the Small Claims Tribunal. So I thought that would be the fastest, quickest way. However, I mean, of course, if the amounts go in excessively large, then you probably need a higher counsel to represent you.
Okay. You have anything to add?
Yeah, and unfortunately, when you talk about freelancers or platform workers, they are not employees. So they do not fall within the preferential debt that I have mentioned. They will be treated as an unsecured creditor.
That's right.
So they will queue up like the rest of the unsecured creditor. And most of the time, frankly, they won't get any money from a liquidation scenario.
That's right.
Or even if they do, they get 10 cents to the dollar, and then that's 3-4 years down the road.
So that's why
yeah.
that's why in our previous legal primers as well as our pocket series, which is a part of our 3-piece meal under the LawWorks partnership, the pocket series, the legal primers as well as our legal clinics, is we've given some advice to freelancers to, well, when you get into a contract or maybe a purchase of your service or a buyer, you get into a contract with a buyer of your services, important to build in some of these provisions in the contract, like periodic payments, a schedule of payments, so that you don't get left high and dry totally. Yeah, because the last thing you want is it'll be a 1-2 year kind of contract,
Right.
and then if you did, I'll be paid at the end of that 1 or 2 years, and then suddenly at the 11th month or 23rd month, the company goes into problems and may have to. Then your so-called your money's owing or your debt won't be fulfilled, and therefore you get into trouble. So it's good to have some form of schedule of payment. That's what we advise our freelancers who, particularly many of you here or tuning in, maybe freelancers, to have to build into your the contract that with the buyer of your services for some form of deposit, your payment schedule of sorts, progressively, so that you don't are not left high and dry at the end of the day.
Okay. So I'm going to come.
Sorry.
Yes, Ian.
No, I just want to clarify and correct what I've just said just now. I mentioned that the platform workers are not ranked as preferential debt. Under the IRDA, they are not ranked as preferential debt, but under the Platform Workers Act, they actually are given some priority in the sense that after all employees have been paid, then they will get paid first before the other unsecured. So they do enjoy some form of priority.
Okay.
But my caveat is only platform workers.
Only platform workers.
Yeah, so that segment, because even if you talk today, we have about 180 to 200,000 freelance professionals, what MOM classifies as own account workers.
Correct.
And this segment, it's not all the 200,000 of them, but only platform workers.
So you were talking about ride-hailing drivers, delivery workers. Yeah, they are protected under the Platform Workers Act.
That's right. And I also just want to add, for the benefit of those of you, because Yee Leong alluded to the IRDA, ERDA. It actually refers to the Insolvency and Restructuring and Dissolution Act. It's a new, we amalgamated 4 years back. We amalgamated many of the different insolvency legislation and provided this, I wouldn't say omnibus, but a consolidated piece of statute to cover all situations as envisaged.
Okay. One day we'll do a webinar on short forms. It's so many of that.
Acronym. Yeah, we all love that.
I want to circle back to the workers who feel obligated to continue for a company that's going towards closure or is under strain. Like you say, it's our loyalty pressure. Sometimes they may be the only breadwinner also. There's no right, there's no wrong. But Patrick, when someone, let's say a boss asks you, hang on a little bit longer, we will get there. What should workers clarify before saying?
I have personally encountered many of these situations where sometimes the company goes through a judicial management, or sometimes they know it's impending winding up or liquidation, but they still hang in because they could have been with the company for decades. Some of them even family, friends, relatives. So our advice is usually you need to assess for yourself, your situation, your needs, whether you have dependents. You still have your mortgage to pay. Sometimes some of them, your housing loans and car loans, whatever. So I thought very, very important. You need to do a self-examination assessment. You call the shots. You decide. Yeah. If like what Yee Leong mentioned earlier, that's why I asked him that question as a hint to all of you. Depending on what kind of situation it is, it may well be a situation where you might end up not getting a single cent, or at the end of the day, after the whole process is seen through, you might have lost your job. So it all depends. It all depends, and therefore you need to make assessment, make a judicious one with all the things that we have shared, and all the red flags that you look out for to decide whether are you willing to stay the course, take a major pay cut to tide through, as fast as 3 to 6 months or as long as years. So you need to make a very value judgment for yourself whether you're able to do that. And of course, like I said, many other circumstances come to play. Sometimes it's a family business, sometimes it's well, it's more than just your salary. It could be other arrangements that you have with your employer or the business. So my advice is if you assess that the company is gonna not is on the road of, or should I say on the slippery slope downwards, my advice is really try all means, pick up new skill, find a next job, so that you can move on. I mean, in fact, if the company does come back as a going concern or does survive the ordeal, they may hire you back simply because you have been a loyal employee, or you left because you had to sustain your all your obligations and to maintain your family, etc. So I think the companies would understand. So I've seen companies that go through difficult times, they lay off the people, and then suddenly there's a recovery. Yeah, I don't mention company names. Yeah, in fact, quite a number of companies I personally witnessed where they had to lay off massive amount of people. But within like 9 months, they had to hire everybody back and now add on more people because there's a sudden, upswing of the
Recovery,
business.
yeah.
So it all depends.
Anything to add?
I think in this kind of situation where people hang on because of sentimentality, because of loyalty, there is a lot of time that has been invested by the person in the company, right? So at times I felt that maybe they are no longer objective about the whole thing. I think it's easier for us sitting here to say, oh, you got to assess, balance your needs against the needs of the company and see whether it's still worth doing it or not. But a lot of times I think people are so caught on with it that it's difficult to be objective about it. I think get help if you are in that situation.
You're right,
Yeah.
because I remember vividly as one of the cases where the company is gonna, it's a matter of time,
Yeah.
but the employee has been in the company for like 3 decades,
Yeah.
and not being paid for 6 months already.
Oh my God.
My goodness
Right.
me.
So I said, I was shocked, I said, you've not been paid 6 months, you still continue working for the company, but like you said, sentimental. So I can only advise you to take the necessary course of action.
Right.
But it's your call,
Yeah. But get help, talk to someone
Yeah.
who can provide you with an objective point of view, who is experienced in this area, and see, whether it is worth your while to carry on in that kind of a situation without causing too much harm to yourself.
Yeah. Okay, so we can take a couple of questions from the audience. We have someone from a small company who is going to be closing down because the boss is old and has no successor. It is a very small company. Someone's asking if the workers are still entitled to any retrenchment benefits. So I think that would really depend on the contract. I don't even
It
know.
depends on the contract, because retrenchment in Singapore is all contractual based, right? There's no law.
Well, there's a provision in EA, but
Yeah.
it's a negative eligibility
Correct,
clause.
correct.
So
Negative eligibility clause.
it's a Chapa advisory.
Yeah.
Yeah.
But
So
there's nothing in the sense of imposing an obligation on employers to pay retrenchment benefit. So it all depends on the employment contract that you have.
and also, you never know. I know our NTUC in the labor movement, we are going quite big into SMEs now.
Yeah.
We organize quite a number of SMEs, and if it's a situation where you're in a unionized company, I don't know. If you're a unionized company, give us a call, because in situations where in unionized company, we tend to have proper negotiations with the company, either the HR or the boss, to have in a way, a fair and responsible retrenchment in compliance with the tripartite advisory. And if not, then we have to escalate the matter to the Ministry of Manpower to sort of conciliate. And of course, we'll take reference to the tripartite advisory. And the tripartite advisory actually says and provides 2 proxies. Firstly, it does explicitly mention, depends on the industry practice, but otherwise the norm is 2 weeks to 1 month per year of service, up to a cap of 25 years. That's the usual iteration in the advisory. in our practices, we do, in most instances, lock in the formula in our collective agreements. Otherwise, industry practice plays an important part. Why do I say that? I remember appearing before a group of workers in the Industrial Arbitration Court because the company only wanted to pay, for example, 1 or 2 weeks. In that case, it was 2 weeks per year of service. But the industry norm for that particular sector was actually 1 month per year of service. So we brought the case up to Industrial Arbitration Court, alluding to the fact that actually more than 30, 40 companies in the same sector, adjacent sectors as well, paying an industry practice of average of a month per year of service. And lo and behold, in the judgment, I remember Justice Chan saying on in presiding over it, and there's a GD on it, a grounds of decision on it. You can search LawNet, where actually he did articulate that because industry pays this much, so he gave a judgment for the claimants, in this case the unions, to say that you should pay according to the industry norms and average. So I thought this is important, doing for the employment lawyers out there who are advising companies who intend to carry out exercises.
I have another question. If the director of a company makes a commitment to repay employees and obtain consent to reduce salaries temporarily, but the company does not survive the restructuring, is the director personally liable?
Generally, I would say no, unless there are certain clauses or certain indications or certain agreement that the directors have made to make himself personally liable. Generally, as we all know, directors are not personally liable for a company's debt, but obviously there can be situation where collateral contracts can be entered into. So it all depends on the situation.
Okay. Patrick, anything to add? No? Okay, I know you all both have answered all my questions, right? So I'm going to scroll down to help and pathways and support because I think it's very, very important about this journey, right? If you're on this journey, workers is always thinking, where do I go? Who do I ask? Who do I talk to? And what sort of support is available? So Patrick, when workers are facing restructuring or closure, how can unions and NTUC support them?
Well, I need to do this pitch like
Yes, please.
See the labor movement. Here, union member, of course, membership dues are only $9 a month. But more importantly, if you're a union member, then we can give you advice and access to justice and to help in more ways than one. Particularly whether in a unionized or non-unionized company. I need to explain this because in a unionized company, we have a lot of powers given because with a unionized company where there's union recognition, then the entire provisions of the Industrial Relations Act, including Trade Unions Act, etc., will kick in. And therefore, that gives you additional measures, as what I alluded to earlier, where we collectively represented a group of workers for their retrenchment benefits or even sometimes annual increments and bonuses to escalate it to Ministry of Manpower and then subsequently to the Industrial Arbitration Court, which is actually presided in this case by a High Court or Supreme Court judge, and with a tripartite panel, one representative from the Labour Movement, one representative from the Employers Federation. So that's the usual. There's one route of a way to get help. That's for unionized companies. There'll be industrial relations officers and the entire labour movement to back you up. However, in a non-unionized environment, we have the Tripartite Alliance for Disputes Management, TADM for short. So that's something we sort of created quite a number of years back, together with the Employment Claims Tribunal. This tool will give you all quick and economical access. However, only for statutory claims and we have add on after amendments a couple of years back, unfair dismissals as well. So that's another route you can go to file a complaint or a dispute. And if you are a union member, I actually have colleagues staffed at TADM together with the Tripartite Alliance for Dispute Management team, including Ministry of Manpower officers, and they will give you more prompt, effective, and hence guide you through the process in trying to resolve whatever claims that you have, disputes your company. So this is the union those who are union members. You go through this track. If you're not union member, then as shared earlier, if you are in a contract of service employee or in an employment relationship, TADM is one route you can go to. If you need quick advice, you can tap on our legal clinics, not just by Pro Bono SG, but also through the various legal clinics available through our LawWorks legal clinic if you're a union member, and to get advice, quick advice to tell you at least where to go and what next. We cannot represent you, but we can give you advice to where to go next. And of course, there's also very useful information on all our platforms, NTUC website, MOM website, as well as the TADM, through the, now with Google and with ChatGPT, but do verify the facts, do a fact check. Because some of them may be shot from sources that may be outside of Singapore, and then you get a bit different opinions. But more importantly, there are resources out there you can tap on which provides FAQs, and we even have robo-advisors to tell you very, very simple, very rudimentary advice to how to navigate the next steps. So not to worry. We're not short of resources. The thing is, you need to know where to go, and so now it's peacetime. Unless, of course, you are facing a real situation, then call the various helplines depending on whether you're a union member or not union member, and the resources are out there.
Okay. So can workers benefit from the government short-term relief fund, ST? Who's entitled?
Yes. This came about partly because the labor movement lobbied for it, because as what Yee Leong alluded to earlier, not all companies that go through the whole process, liquidation, winding up, judicial management, receivership, will end up surviving. So there will be companies that or there will be workers that are left high and dry. However, we want to give a bit more support to the lower wage workers. So for the lower wage workers, they can actually apply for this short-term relief scheme administered by Ministry of Manpower. In fact, I spoke about it recently in Parliament, asking Minister whether can you expand the scheme to include freelancers, because now freelancers are, as you know, there's a recent case, don't mention which company, some of the private hire vehicle drivers are left in the lurch because they've rented a vehicle and the rental company or the vehicle leasing company goes bust. So I've already put a lot of deposit there, the unsecured creditors, and what happens to the deposit, and what's next, and whether they're not paid this, not paid that, whatever. So I think this is a growing thing now that we have platform workers amidst us. So I think short-term financial relief scheme is something we should review and maybe expand it wider.
Okay, so maybe I have a question for both of you. Maybe I'll ask Leong first. Some workers sometimes worry seeking help too early, right? They will rock the boat, or they send out those kind of vibes, and they don't want to stir the pot a bit. What would you say to them, especially when they're risking waiting for a long time? What kind of advice would you give someone?
I think it's not disruptive to seek advice early. In fact, I would really advise people to seek advice early, because the earlier you seek advice, the better your options are, right? And when you seek advice, it is confidential. You need not necessarily tell your employers that you're seeking advice. You can go to the legal clinics. You can go to all the help stairs that Patrick has talked about, to talk to people. Like I say, talk to people with the expertise in this area. Talk to people with more objectivity, Then you know what your options are. Then it's easier for you to make a decision as to which path you want to take. Okay, so you shouldn't see seeking help as being disruptive or being not a team worker, right? It is important, even if you are a team worker, you want to help the company, it's always good to know what your options are first before you get into that, rather than blindly moving along without knowing where your options are.
Okay.
Maybe just to add on one point to what I shared earlier, for the benefit of everyone who's tuning in case you're not aware, Since April 26 last year, the government started something called the Job Seeker Support Scheme. It's something which myself and the Labour movement, we've been lobbying for more than a decade, and finally, they roll out this scheme. This scheme is administered by the Ministry of Manpower to Workforce Singapore. And well, this scheme, why I need to raise this scheme up for the benefit of all of you is if you are for the past year, or even if you are involuntarily made or involuntarily unemployed through retrenchment, to be a termination, contractual termination even, you may be entitled to some financial relief. And this over and above the short-term financial relief. This applies to all workers. However, there's some conditions. Well, if I may flag two important conditions to be entitled to this payout. The total sum of this payout will be $6,000 for a period of 6 months. So that it varies after application. Of course, you must be involuntarily unemployed, not because you resign and you want this tap on this benefits. It must be involuntary. Retrenchment will fall into it. Contractual terminations will fall into it. But two important characteristics of this is that you only, because it's a scheme where it's not like unemployment insurance, where you co-pay and employer pay a bit, you employee pay a bit. Here is only borne by the government. So therefore, there's no payment of any premiums, etc. It's just application, but you need to comply with two things. Your last drawn salary on average should not be more than $5,000 a month. And that actually covers about half workers. Median salary in Singapore is around about there. So about half of the workers. And the other one is also, there's what globally we call active labor market policies. Meaning that you can't just go there, apply and get the monies. You need to participate in some activities to help in your future employment and your employability. For example, going for some training, meeting a career coach, attending some of the job fairs, attending interviews that are referred to you, and taking active, not proactive steps. Of course, guided by some of the employment coaches, both from E2I as well as WSG, to land the next job. So I think you must show that you put in the effort, and this stipend, so to speak, or job seeker support scheme will help you tide through. It's not a large sum of money, but good enough to help you in maybe transportation, daily sustenance, to move from point A to point B for interviews, for training, etc.
Okay.
And this is over and above all the other skills future programs where you go for training heavily subsidized, especially for Singaporeans, as well as all the training allowances that come with some of these training schemes.
Okay. So we're going to take a couple of questions because we are almost there to round this up. So the first question is, according to TADM, this person says that the website on TADM's website says you cannot claim retrenchment benefits unless it's an employment contract or union contract. Is it true?
Yes.
Okay.
Yes. As mentioned earlier by myself, basically it has to be statutory claims or contractual claims, and it's quite difficult if there's nothing on black and white. So unfortunately, because if you go to TADM, the final arbiter is likely through the Employment Claims Tribunal, and just as a court of law, it must be evidentiary proof that there was an agreement or a contract that you'll be paid, or there's some terms, very clear, explicit terms that you are paid, not something that, but however, in a unionized environment, so that's why we encourage all you to be union members and be a nice company, because then you have the Industrial Relations Act that comes in. You have the collective agreement, and I mentioned the whole alternative dispute resolution process is slightly different. We can do it collectively, and we can represent you either individually in a limited fashion, including for retrenchment, which is one of the limited representation areas, all the way up to industrial arbitration. So slightly different.
Okay.
So if you're not union member in a non-unionized company, then it's a quick economical access to justice. So that's at best what's available at this moment.
Anything?
Yeah, I think that's basically the like I said earlier, retrenchment benefit has to be contained in either the agreement or the collective agreement that if you are a member of the union. So and if it's not there, then it will be difficult
Okay.
to launch any claim.
So then it leads me to the next question. Is there a cap on retrenchment benefits?
As some of you have tuned in earlier, I mentioned about the tripartite advisory or managing excess manpower and responsible retrenchment. So in it, there's alluded to, like I said, the quantum of the retrenchment benefits. There's some proxy or provisions in that advisory to the extent that it's 2 weeks to a month. In general, unionized companies about a month. However, there's a cap of up to 25 years or months. Not months, but the 25 years of service. That's the tripartite agreed cap of retrenchment benefits. However, all said, personally, as a practice in some of our unionized companies, because I think some of the employers value the service and the loyalty of the employees, they well, if they are more generous and they don't have a cap, we don't stop them. In fact, quite a number of companies now, particularly in our unionized company, they've been very progressive. But they want to value and those employees that have been with them for a long time, some 20, 30 years, 35 years. And if they were with the company and the company was doing well, and the company is doing not so well, they need to cut costs or last resort cut headcount. I think they also want to give back to the employees. So I think some of these progressive companies, I'm glad to share in Singapore, we have quite a number of them where they don't follow the cap. So nothing to stop. So there is a cap, but as a tripartite advisory, nothing to stop companies wanting to pay a bit more to value their employees.
Okay. So, I will ask you this last question, second last. Workman compensation pending in company, subsequently in liquidation. What is the priority of this compensation?
I think workman compensation comes within the professional. I think it ranks after salary, after let me see now. Salary, let me see, I've got the list there. I just talked about it. Yeah, salary, retrenchment benefit, then workman compensation third.
Oh, okay.
Yeah.
Okay, I hope that helped you. Last question. Can employees of a subsidiary company transferred to a parent company be asked to relinquish their current or existing portfolios and take on new and unfamiliar roles?
Yeah, so that's a very vague description of the entire arrangement. We frankly, you can't give you a definite answer, a definitive answer, simply because it's quite vague. Because you need to really dive into the actual, what kind of subsidiary, what kind of holding company, what was the actual transaction, and how was
the employer is,
exactly.
right?
So, a number of variables.
Right.
Yeah.
Let's take, for example, if the employer is the subsidiary and he was employed by the subsidiary to do certain part, then you cannot just transfer a contract out from the subsidiary to the parent company and ask him to do a different job. That is a straightforward situation. But like Patrick said, there are so many other permutations
Yes, this is
of that question, right? So it all depends on who the employer is and how the employment contract is structured.
Yes, that's right.
To see whether such thing can be done. Yeah.
Okay.
Yeah.
So we're almost finishing. But before we close, I would like each of you to think about one key takeaway, at least one thing you would like our viewers to take away from today. So, Yee Leong, I'll start with you first.
Right. I think we have been talking a lot about restructuring, reorganization, whether solvent, insolvent, and liquidation. I think the most important thing is if you suspect that some form of such things is going on, get advice early. That is my advice to workers. Don't wait until things happen or in fact applications have been made to court, then usually it's too late and the options will be tremendously limited. So always get advice early, get help. Not necessarily have to go to a lawyer or someone, but there will be plenty of help. I think Patrick has mentioned a lot of the resources and the avenues that are available. Go to that and understand your own situation. Recognize what when you are facing. I think then it'll be easier for you to manage rather than dealing it at the end of the process.
Thanks, Yee Leong. Patrick?
Just an Eli advice, all of you who may face impending challenges. My advice is actually to the HR, employers, businesses, business owners, and in Singapore is uniquely tripartite. So do keep abreast of some of these developments and some of these schemes that we have shared earlier. for the past hour and a half, and where to go to, etc. So not to worry, even employers, businesses, help is at hand to help you navigate some of these more all this whole plethora of services and resources. More importantly, be aware Singapore is uniquely Singapore. Yeah, especially some of you who may be operating outside of Singapore may not be used to the system here, but rest assured in Singapore, we work in a very collaborative fashion and do make reference to all these tripartite advisories and guidelines that are fleshed out. Do not neglect them. Why do I say that? Because I think our courts have made very explicit mention of tripartite guidelines and the fact that in judgments, even in statutes, for example, the Employment Claims Act, Section 20 of it, as well as even in the IAC, there are specific explicit references to tripartite guidelines that although they are not law, but it's going to be very odd for a court of law or when we arbitrate or when we mediate to run foul or deviate from what's provided or guided in the guidelines. So I say take the guidelines and advisories seriously, so that you'll be able to be fair, responsible, and hopefully progressive.
Thank you both again for sharing your insights and for all the explanations much more clearer. And to our viewers, the aim of today's webinar is not to alarm you, but to keep you informed, right? So that you can make a calm, considered decisions rather than reacting based on assumptions or incomplete information. Now, there were several resources and links that were shared during the session and the chat. If you had missed any of them, don't worry. They will be included in a follow-up email that will be sent to you shortly. If you're facing challenges and you need further assistance, NTUC members may seek support through their union channels or register for a legal clinic session by emailing lawworks@ntuc.org.sg. Non-members, you can reach out to Pro Bono SG at help@probono.sg. At the end of today's session, a short survey will appear on your screen. We really would appreciate your feedback as it helps us improve our future sessions. On that note, thank you everybody for tuning in, and thank you again to our panelists for clearing the air. Have a good and restful day. Thank you.
Thank you very much.
Okay.
Good night, everyone.